Okay, yeah. So this one, Minnesota sues Exxon, Koch Industries, and the American Petroleum Institute for, quote, 30 years of a campaign of deception on climate. So this is awesome. So these guys have been lying to us for decades, and we talked about their PR campaigns in the past. And I want to stick to the script here because this is a lawsuit. So Minnesota is the latest in a growing list of local governments from San Francisco to Rhode Island that are hoping to hold the fossil fuel industry accountable for the climate crisis. They are accused of knowingly directing, conducting, and funding campaigns to deceive and defraud Minnesotans and Americans. As these various lawsuits have gone on, documents as old as 30 years old have been discovered that demonstrate that they knew that climate change was a real problem. Exxon's internal documents acknowledge that CO2 was increasing, that it was caused by burning fossil fuels, and that it would cause, quote, dramatic environmental effects before the year 2050. And yet they spent millions of dollars on campaigns to sow doubt in the science. So these PR campaigns said things like, "Who told you the Earth was warming? Chicken Little." So Minnesota has itemized their costs that are related to this. The $614 million that they've spent on asthma treatments in 2014 alone, and the $165 million they spent on flood disaster relief in 2007. So their lawsuit is using slightly different techniques than some of the others that have been out there. So it'll be really interesting to see how this plays out. And we've talked about how these PR campaigns use the same sorts of underhanded techniques that the tobacco industry used. And while the tobacco industry had a massive lawsuit and had to pay the states a lot of money that went towards health and other awareness campaigns. So I would really like to see this same thing happen here and have the fossil fuel industry held accountable for all their deception.
Turn those unpriced externalities into priced externalities.
Mm-hmm. Exactly.
But I mean, didn't we have evidence from Exxon? What is it? 1947. They had documents. Like, there's not even a computer on everybody's desk at this point, and they're telling us how bad it's going to be, and it's tracked. They were within what, 3% of 47?
Yeah, those internal documents have been leaked. They've been put out. They've been. I mean, it is incredibly damning. And yes. I find it hard to believe that they have been taken to court multiple times. And the courts have said, well, it's not really up to us to decide. Right. But like Patrick said, the thing is, a lot of these previous lawsuits were just, states, municipalities pointing their fingers and saying, but they knew. Uh-huh. And the judges are like, well, but what are we supposed to do about this? But like Patrick said, Minnesota is saying, their wanton disregard for the facts and the fact that they intentionally buried their own studies incurred damages, and we are suing for damages. Now that's a completely different thing. You can sue for damages. Now the judges have to step up and they have to say whether or not Exxon and Koch are liable for the damages that they incurred.
And then, once it succeeds, you've got precedent, and everybody else comes with the handouts.
Exactly.
Well, this is why when you're going to do a court case, if you're going to do a court case, you really have to understand that you need two important pieces of things to have a successful argument. You need to have a clear person for whom what happened affected them. There has to be somebody with standing for this case to happen. And Minnesota is showing that they, as a state, they do have standing because these are the damages that they've paid out over the years. And Exxon themselves, with their 1979 document, shows that they knew of the problem. And the 1991 document for their information council, where they basically said, okay, here's how we're going to make sure they don't get us to regulate anything we're doing for the environment. So you do have a sign that there is a clear showing that they knew what was happening and they took steps to obfuscate any responsibility and any mitigation efforts being legislated. So this has way more of a chance of actually amounting to proper damages than just about anything else that's gone up before a judge. So a judge can hear your argument, but if you cannot clearly state this occurred, these damages occurred to my client, this is what they would cost in something for the restitution, and here are the remedies we are looking for, you're probably not going to succeed in that case, because there is no such thing as settled law, but you can establish a precedent. And you can't have them, they can indict a ham sandwich, but they can't make the ham sandwich go to jail. So you have to think about all of that stuff.